Victims have the right to participate in ICC proceedings. Now, what does that mean? The idea behind victim participation at the ICC is to ensure that victims have a sense of ownership over the process. An international criminal proceeding happening in The Hague can be quite an abstract concept to somebody living far away. To give them procedural rights, to give them a voice in that courtroom proceedings, helps to bridge that gap, to span that distance, and to make these proceedings more relevant in the countries in which they arise. Now, some of the procedural rights that victims have before the court are the right to participate, for example. Now, what does the right to participate mean? Victims, by completing an application form, have the right to tell their story. By completing the form, they tell the court, and particularly the judge in a specific case, what in fact has happened to them and how the alleged crimes have impacted on their lives. If the judge is convinced that this victim is in fact a victim falling within the specific confines of a particular case, then that victim will be entitled to participate through a lawyer. And that lawyer, rather than the victim, will be sitting in the courtroom in The Hague, day in and day out, listening to the evidence being presented, having the opportunity, if the judge agrees, to question witnesses, and put forward, where appropriate, the victim's point of view. At the same time, that victim's lawyer has the responsibility of traveling to where the victims reside, keeping them informed about the proceedings, but also taking instruction, and so that allowing the victims to provide their views and concerns to the judges in the proceedings in The Hague.